Hi, folks. How are you? I'm glad to see you back again. This episode, we're going to talk about three things that could hold up your probate process. And that could be anything from, darn it, I didn't get what I wanted, to, darn it, I didn't get my share. Let's get started. So, anyway, in the process of doing probate, there's a couple of things that commonly happen to the entirety of the situation. One is people are hurt because either mom or dad or uncle or Joe, or your uncle Jojo or your aunt Jojo or passed away, your grandma, your grandfather, etc. And in some cases, you will have contested wills, and in some cases, you will have intestate succession. So there's nobody really to sue because it all goes to everybody, but they're not aware of it. And then there may be some executor responsibilities that people don't quite understand that they will contest because they don't understand. And um, let me put the asterisks here. There are some attorneys who just don't know what they're doing, and they have to be admonished in court because the certified estate specialist knows more about what has to happen than the attorney does. I've had that happen twice, and it's unfortunate that they go through 7 years of all of this stuff in order to just chase a dollar bill. And it's really disgusting that they do that. So, a lot of people ask me why I charge so much for what I'm doing. And believe you me, what I charge is less than what an attorney charges. I mean, it's really less than an attorney charges. So an attorney will charge anywhere from $350 to $550 an hour. And I am $300 an hour. But see, the attorneys, they have blanket indemnity. So if they screw up, well, they get off scot free, whereas I have to post bond. And what happens when I have to post bond is I go down around the corner, say this is how much the assets of the estate is worth, and pay that bond. The reason why you have to do this is because you're going to have somebody who's going to contest the will or contest a decision or think that you are the reason why they're not getting their fair share, or they think that there's more money in the estate than there is, and they can't come up with any kind of proof. So they sue you. So that's the reason why I tell everybody to go get a bond. So in case this does happen, then the bond will pay for that. In some cases, you have to have a competent lawyer to defend against that. And of course, that is going to pay, you're going to wind up paying for that as well. Sometimes I'll do it myself because I know that the law is written very distinctly, very succinctly, with a period, not a question mark. So they will argue over all of this stuff during a contest, and if somebody will eventually contest the validity of a will. And you have to think about it like this. I'm going to give you a scenario. A will was written in 1990, naming their youngest individual as their executor. Okay. In 1990, the individual was 20 years old and was going to college and did not stay pretty much at home unless it was to go to sleep, practice some things, or do their homework overall. So a lot of people will say, well, that's grounds for contesting the will. So what they'll do is they'll contest the will either by saying that the individuals were out of their mind when they did it, the signatures on it was not correct, the will was written in another state and does not account for the laws in this state. I mean, there's a whole slew of of things that they will contest the will for. The court may require a hearing to resolve the dispute. In those cases, the individuals have to show up in front of a judge and say this, that, state their case. And 9 times out of 10, there's not a lot there for them to prove. And what I mean by that is that they're making a claim, but they have no evidence. And so what they'll do is they'll attempt to get the individual that they're charging to go gather the evidence for them. Well, I charge $300 an hour to go get all of that. And a lot of people don't realize that when it comes to the closing of the estate, it's usually when those bills come due. The attorney's fees, my fees, or any of that other stuff. And it will rack up a big bill if you have somebody who contests the validity of a will for no apparent reason other than to be that guy. So understand that whenever you contest a will, it's going to cost a lot of money. $7,500 at the minimum, more than that at the maximum. And if they find that the will is not valid, then anything that's been distributed, even if the person who sued you has to give all of that back, because now it goes to a different stage. Now it's going to be court supervised in some cases. Common grounds for contesting a will includes the lack of testamentary capacity, meaning the individual might be deemed as incompetent, undue influence, or fraud. And it's difficult to prove undue influence, especially when the will is pretty much laid out. And the will was pretty much laid out in this 1990 will back in 1990. So there's not a lot of undue influence that can be done. They wrote the will out. It was done in another state. They signed it in this state, and it's been part of the lockbox ever since. And fraud, again, you have to prove the fraud. If it's out and out, you got somebody on camera picking up I'll give you a fraud instance. There was an uncle that passed away years and years and years ago, probably about I want to say somewhere in the 86-ish era. And one of the nieces of him went and took the car and poof, disappeared before before the estate was even open, before the executor was named. And as time went on, well, they wrecked the car and they still didn't pay the estate for the money, even because she was not even named in the estate as a beneficiary or an heir, and he had a will. So you will have that kind of fraud go on inside of families because they think that they're due something that they are not. So understand that a contested will can take shape in many different factors. So let's talk about intestate succession. Intestate is when somebody passes away in North Carolina and they did not have a will, or they have an unproven will. And in order to prove an unproven will, you have to find the original people who did the signatures on the will, and then have them take the will and do their signatures in front of somebody, and then have them notarize that the signature does appear to be of that individual. If they don't do that, then it's considered intestate. And what happens when somebody passes away intestate, if the deceased dies without the will and you cannot get a proven will, North Carolina's intestate succession laws determine how assets are distributed. So generally, the assets go to the closest relatives, starting with the spouse and then the children. So what that means is, say, for instance, if somebody has a if somebody has a settlement, well, guess what? That settlement, if their spouse is there, goes to the spouse. If you have an estate of the spouse and it goes to this individual, then it goes to the estate of that spouse. Now you're going to have some attorney saying that's not true, and you guys are coming out of your chair right now because I challenge you to prove beyond a reasonable doubt that that's not how it is. But if you have an estate of the spouse and you have a settlement over here, then it goes to the estate of the spouse, and then the estate then distributes all that money. In some cases, it will go to the children or any of the identifiable people who are part of that family. And it's not always the case. You may have debts, you may have other things that have to be distributed accordingly. Uh, and then that's how things happen intestate. But if you have somebody who's intestate, then the sales of all of that will then go to the spouse or the children as a step. Intestate is a step. If there's no spouse, then it goes to the children. If there's no children, then it goes to the children's children. If there's no children's children, then it goes over to a brother or a sister. If there's no brother or sister, then it goes to their children. And if they don't have any children underneath there, then it goes up. Then it will go up to the parents. If the parents aren't there, then it goes over to an aunt or an uncle. And if the aunt or uncle is not there, then it goes to their children, et cetera, et cetera, et cetera. So it's really easy for a child to be over here who has given up for who has not been documented to completely not even be made aware that this person over here passed away. And in divorce, it gets extremely more difficult because now a perfect example is you have a divorcee whose father died. And not only does the father now have children in that family, but he still has children over here in this family who has a claim against the estate. Only because there may be 3 over here, 6 over here, but they all have a claim. And, I've seen it a lot of times where they're divorced, don't want to talk to the kids, don't want to even deal with them. But yeah, he's my firstborn. It happens. What are you going to do? You have to treat them just like their blood, because when you die with a will, you do whatever you want with a will. When you die intestate, then it goes by bloodline. Bloodline versus your wishes. Bloodline versus your wishes. It's up to you how you want to do it. Get the will done, bloodline. You have no control over the bloodline. So the important thing is that an administrator can be assigned to somebody who's intestate, which is fine. So they're just called an administrator. They're not called an executor. So the administrator or the executor's responsibilities must act in the best interest of the estate and the beneficiaries. They can be held personally liable for breaches of their fiduciary duties. And that is one of the things that people often will conflate, is that they're trying to contest a will, but they're suing the executor for personal malfeasance. And the executor, there's no malfeasance because this is what the will says. Are you contesting the will, or are you contesting the actions of the executor? I've seen it where the executor is sued the day after he's sworn in or she's sworn in because they're contesting the will, not the executor. So they have to sue the estate for the will. They sue the executor or the administrator for their malfeasance. And I'm going to tell you that executors, administrators, they can do it exactly how it is supposed to go. Such as if you have a settlement and you go and you say, hi, I'm the administrator of the settlement, they go and they cut the checks to the appropriate people, and then those checks go where they need to go. Okay? they will turn around and sue the administrator because they don't think that the checks are supposed to go to them individually. They think that a check is supposed to show up at their front door and it's supposed to cost money, or it's supposed to be for all 30. There's a $30,000 settlement and there's four of you that have to share in that settlement. They think that they're going to get a $30,000 settlement. So the other thing too is, and there's a couple of warning signs that your siblings are going to be a problem. One is they call somebody who is uh, outside of the settlement. So, say for instance, you have a settlement claim over here. Well, they will call that individual to the point of harassment in order for them to release the funds, and they're only allowed to release the funds to the administrator or the executive. Period. That's it. So they'll sit there and they'll harass that person, thinking that they're going to get money if they just get them to, or they're gonna pay them money, or they're going to extort this, that, and the other. All I can tell you is that's a felony. If they cut money to that person to shut up, that is a felony. A lot of people don't understand that. That's a financial fraud case to which it takes the settlement claimant or the person who has the claim, and that one person who keeps calling them in order to get money to extort them, in order to shut them up. They don't represent the estate. The administrator down here represents the estate. He's got all the paperwork. She's got all the paperwork. And all that money flows right into either the estate of the spouse or the spouse, and then it gets distributed after that. So they don't realize that sometimes what they're doing is the first step of fraud, financial felonious fraud. The executor and administrator, no matter what, has 100% of the capability to handle all of the estate functions unless there is a letter saying, Susie, under my authority, has the privilege to sell the car to the dealership in order to, and here's the title, and it is owned clean, free and clear. Not Susie takes the car and goes and sells it and then says, oh, well, there was more money owed on it than needed when you have a free and clear title, and Susie kept the money. You have those inside of some of these situations. So be careful, because when the patriarchy or the matriarchy passes away, then sometimes the true person comes out, because the mom and the dad were holding that person together. So just to recap, navigating probate in North Carolina requires careful attention to detail and adherence to legal requirements. By understanding the steps involved and seeking professional guidance when necessary. Now, understand that professional guidance does not need to be an attorney. It could be a CPA, could be an auctioneer, could be an estate specialist. It could be a real estate specialist. It could be any of the professionals that handle these by bulk. It could be even a PA or a estate planning attorney, etc., or an estate planning company. Then that allows you to have some kind of breathing room. And executors and beneficiaries can ensure a smoother process. And what I try to tell people on a regular basis is that you have the attorneys here that are doing a lot of the legal work, and then you have me over here doing a lot of the practical footwork, and then in the middle we have the executor or the administrator. And the administrator is seeking the legal advice of the attorney and seeking the practical advice as to where to sell or how to get rid of certain things from my side of it, or the practical side. And it's a very important to understand that, because attorneys don't have time to be doing all these estate tag sales, even though they're specialists in doing estate work. They're primarily specialists in doing estate work on the legal side, representing you in a court of law. The practical side is they represent you in the sales side of it, the real estate, the personal property, the transactions when it comes to financial instruments, gold, silver, coins, that kind of thing. Whether dealing with straightforward estate or a more complex situation, such as having a corporate interest, um, industrial interest, real estate interests that are outside of the home, uh, the key is to approach probate methodologically with a method, and respecting both the law and the wishes of the deceased. A lot of people will say, I've got this CD and my grandmother wanted me to have it, but she never put that CD in her will. So it the chances are it's going to get sold, and that money's going to be distributed. Or if it's a $4,000 CD, then the rest of the family has to have $4,000 amongst them as well. Anyway, that's all I got for this session. I am Matt Price. If you have any questions, give me a call, 919-614-6288, or matt.price at ebbids.com. That's not EBBID. It's not EB dot. It's not EBD. It's EBB. Echo Baker Baker, IndigoDogSam.com. I will be happy to answer any of your calls, questions, texts, you name it. Have a great, great day and smooth probate.